Okay, good afternoon, everyone. Thank you for joining us for this panel on the general law and applied topics. The panel will be addressing the question, what role does general law play in shaping constitutional interpretation, and how does it apply to doctrines such as the Fourth, Second, and 14th Amendments, as well as natural rights and broader legal theory? This panel will explore the intersection of historical legal principles and modern constitutional law, focusing on how courts engage with general law concepts when addressing contemporary legal issues. Panelists will draw on their expertise in criminal procedure, gun rights, and constitutional structure to examine how general law informs modern constitutional doctrines and the ongoing relevance of these principles in today's legal landscape. Our moderator for today's panel is Professor John Duffy. Professor Duffy is the Samuel H. McCoy II Professor of Law and the Director of the Center on Intellectual Property at the University of Virginia School of Law. Professor Duffy has taught international intellectual property law, patent law, administrative law, and the Second Amendment, torts, and other courses. He received his undergraduate degree in physics from Harvard and his JD from the Chicago Law School. After law school, Professor Duffy clerked for Judge Stephen Williams of the D.C. Circuit and Justice Antonin Scalia of the United States Supreme Court. Before starting work as a professor in 2003, Professor Duffy practiced law at Covington and Burling in D.C., and was an attorney advisor in the DOJ Office of Legal Counsel. Please join me in welcoming Professor Duffy.
Well, thank you very much. We have a really terrific panel today, and I'm going to call on or have our panelists go in alphabetical order, which is going to be perfect because we have three remote panelists, but our first panelist is Randy Barnett, who is here. I'm going to introduce the panelists all at once, sort of give their credentials. I think an introduction is usually not all that necessary for such an esteemed group, but I think a few things are worth noting. Professor Randy Barnett is the Patrick Hotung Professor of Constitutional Law at Georgetown University Law Center, one of our fellow law schools just up the pike here. He earned his JD from Harvard Law School, and he worked as a prosecutor in Cook County some time ago. He has worked extensively in the gun rights area, among other areas, and that has become an area of constitutional law that is very much interested in history and tradition, and is probably the single area of constitutional law right now that is at least trying to be the most originalist based on recent decisions. Dan Epps is a professor of law at Washington University Law School. He is going to be joining us remotely. He received his JD from Harvard Law School and clerked for Judge Harvey Wilkinson on the Fourth Circuit right here in town in beautiful Charlottesville, and then on the Supreme Court for Justice Antonin Scalia. He practiced law at King and Spalding, and now hosts a podcast. Podcasts are all the rage about things, called Divided Argument with Professor Will Bode. Robert Leider, one of our remote guests, is an associate professor at George Mason's Antonin Scalia Law School. His interests include criminal law, criminal procedure, and constitutional law. He has written, and I'm sure of this because I read his work extensively, on the Second Amendment as well. I think he has some very interesting originalist ideas there. He has his JD from Yale Law School and a PhD in philosophy from Georgetown University. He clerked for Diana Sykes at the U.S. Court of Appeals for the Seventh Circuit and also Justice Clarence Thomas on the U.S. Supreme Court. And finally, Steve Sachs will be our final speaker. He is the Antonin Scalia Professor of Law at Harvard Law School. He teaches the theory of constitutional interpretation, the jurisdiction of state and federal courts, and the history of procedure in private law. He has his bachelor's degree from Harvard. He was a Rhodes Scholar at Oxford University, and then he received his JD from Yale Law School. He clerked for Stephen Williams on the D.C. Circuit, which is the same judge I clerked for, a really masterful judge who unfortunately passed away during the COVID pandemic. and then Chief Justice John Roberts of the United States Supreme Court. Well, without further ado, I'd like to ask Randy to kick off our panel here with his remarks.
Great, thank you. And thanks to the UVA Federalists for having me here, and also thanks to the UVA Federalists for having this program. It shows that law students can make a significant impact on the course of legal scholarship simply by holding programs like this, and you're to be commended for having established this new tradition. Now, in this talk today, I'm going to take as given that the original meaning of the Ninth Amendment that it has come up several times in the course of this conversation so far is a reference to individual natural rights. And I'm also going to take as given that the original meaning of the privileges or immunities of citizens of the United States is a reference to civil rights, and that civil rights are very closely related, though not identical to natural rights. And then the rest of my talk is about, okay, so what? Now, what do we do? Now, in the rest of my talk, I am going to also take as given the important historical work of Stanford Law Professor Judd Campbell, beginning with his influential 2019 Yale Law Journal article, Natural Rights and the First Amendment. For American elites, Judd writes, rights were divided between natural rights, which were liberties that people could exercise without governmental intervention, and positive rights, which were legal privileges or immunities defined in terms of government action or inaction, like the rights of due process, habeas corpus, and confrontation. Natural rights were those that did not depend on the existence of a government. Speaking, writing, and publishing were thus readily identifiable as natural rights. For the first 150 years of the United States, natural rights were thought, in my view correctly, to be the liberties that one has in the state of nature to pursue one's happiness. They are the individual liberties that are essential to human flourishing. They are not rights to any particular good, like education or health care or minimum income. They are rights to act or refrain from acting. The American conception of natural rights was Lockean, not Hobbesian. For Hobbes, in the state of nature, liberty is unlimited. Everyone is at liberty to do whatever they will or desire, up to and including the liberty to use the bodies of other people. For Locke, in a state of nature, liberty is bounded. Everyone has the right to do what they will or desire with what belongs to them. The state of nature, Locke insisted, quote, has a law of nature to govern it, which obliges everyone that being all equal and independent, no one ought to harm another in his life, health, liberty, or possessions. So in practice, the specific content of natural liberty rights is determined by the private law of contracts, property, and torts, which are part of what some today call the general law. The general private law specifies the rights that each of us has against each other. If we are acting consistently with this body of law, we can be said to be acting rightfully. When we violate these rights, we can be said to be acting wrongfully. Returning now to Campbell, he writes, quote, though easy to identify, natural rights at the founding scarcely resembled our modern notion of rights as determinate legal constraints on governmental authority. Rather, Americans typically viewed natural rights as aspects of natural liberty that governments should help protect against private interference through tort law, property law, and so forth, and that governments themselves could restrain only to promote the public good. I mean, they could restrain these rights only to promote the public good and only so long as the people or their representatives consented. From this, Campbell offers a limited conception of the role of judges in protecting natural rights. Quote, assessing the public good, generally understood as the welfare of the entire society, he writes, quote, was almost entirely a legislative task, leaving very little room for judicial involvement. According to Judd, historically, fundamental natural rights could be regulated by legislatures for the public good, apparently without needing to satisfy much, if any, judicial scrutiny. Now, I think Judd is correct that pre-existing natural rights may reasonably be regulated by legislatures to promote the public good. But his work can be read as suggesting that because a natural right may reasonably be regulated by legislatures for the public good, any regulation enacted by a legislature that purports to be for the public good is automatically constitutional. Now, whether or not that really is his position, I think that position is wrong. Now, in the longer version of this talk, I identify the two prevailing conceptions of constitutional rights, the ones that do prevail today. The first views rights as interests. When important interests conflict, some balance needs to be struck between them. The second views rights as trumps, a label coined by Ronald Dworkin, a term he took from the card game of bridge. With rights as trumps, a valid right must necessarily prevail over any competing interest. Rights cannot be balanced away. Now, I can't critique these two modern conceptions of constitutional rights here, but my bottom line is that rights as interest underestimates the power of rights, while rights as trumps overestimates their power. In this talk, I just want to focus on a third alternative conception of rights that I believe to be both the historical as well as the correct conception of rights, and that is rights as regulable liberties. Rights as regulable liberties. I take this label, rights as regulable liberties, from Judd Campbell and his Yale Law Journal article. There he refers to, quote, ordinary natural rights that were fully regulable to promote the public good. On the rights as regulable liberties conception, natural rights are not interests to be balanced against and overridden by other interests, and nor do they function as trumps, nor do they function to trump any and all legislation. Instead, in civil society, pre-existing natural rights function as constraints on legislatures so as to ensure that laws that purport to serve the common good do in fact serve the common good. Now, I prefer the term common good to public good because the term public good seems to leave open the possibility that the good of the public or the many may justify the sacrifice of the good of the one or more individuals. The term common good, by contrast, suggests that the role of rights is to ensure that any legislative effort to achieve the public good are truly beneficial to everyone in common. But I'm not claiming that that was a consistent historical usage, only that's the reason why I like common good better than public good. Because natural rights protect the liberties that are essential to human flourishing, to the pursuit of happiness or the good by individuals, the exercise of such rights may not justly be prohibited. But such rights may be reasonably regulated to protect their exercise from harming others. Under this conception, rights do not trump legislation that is aimed at a proper end. To be legitimate, legislation that affects a right must truly be aimed at a proper end, however. Thus, the existence of a regulable liberty right imposes three constraints on legislative power. First, the exercise of a regulable liberty right may not justly be prohibited. That's a big constraint. By borrowing prohibitions on their exercise, unlike rights as interests, regulable liberty rights are genuine rights. But unlike rights as trumps, a regulable liberty can be regulated, which gives rise to the second constraint on legislative power. If legislation is restricting but not prohibiting the exercise of a regulable liberty right, such a restriction must not be aimed at an improper object or end that is beyond the competence or proper scope of the legislative power. Competence was the word that was typically used historically. Assertions by a legislature that a restriction of liberty is aimed at a proper end must be in good faith and not be pretextual. As John Marshall put it in McCulloch versus Maryland, quote, should Congress, under the pretext of exercising its powers, pass laws for the accomplishment of objects not entrusted to the government, it would become the painful duty of this tribunal to say that such an act was not the law of the land. Third, because regulable liberty rights are rights, legislatures who are acting in good faith must have some demonstrable reason to believe that their chosen means will actually achieve a proper end. Again, in Marshall's words, a legislative act must be, quote, really calculated to affect any of the objects entrusted to the government. In sum, just as legislation may constrain or regulate individuals in how they exercise or how they pursue happiness, regulable liberty rights constrain or regulate legislatures in how they may pursue the public good. Assuming now that the rights we are protecting are the liberty rights defined in practice by the general private law of contract, property, and torts, what then is the proper end of government in regulating these rights? At the federal level, this is actually a bigger question. I'm going to blow through this really quickly. At the federal level, these proper ends are enumerated in Article I and elsewhere in the Constitution. The concept used to describe when states may prohibit or regulate individual liberty is called the police power. It's an unenumerated power. Under its police power, state governments may prohibit wrongful acts, acts that violate the rights of others, the kinds of acts I prosecuted when I was an assistant Cook County State's Attorney in Chicago. But it may only regulate rightful conduct to achieve the common good, for example, by ensuring the health and safety of the public. Now, assuming the exercise of regulable liberty is not being prohibited, get that off the table, how does one distinguish between a proper and improper regulation of a regulable liberty right? This question was helpfully addressed by Justice Joseph Bradley in his dissenting opinion in the slaughterhouse cases. There he distinguished between the proper regulation of a right, and the subversion of a right. Quote, "The right of a state to regulate the conduct of its citizens is undoubtedly a very broad and extensive one, and not to be lightly restricted. But there are certain fundamental rights which this right of regulation cannot infringe. It may prescribe the manner of their exercise, but it cannot subvert the rights themselves." But how is a proper regulation to be distinguished in practice from a subversion of a regulable liberty right? In particular, how should judges make the assessment? In general, although I don't think this assessment is limited to judges, I'm not going to talk a lot about judges. In general, courts should be looking to identify when legislation is based not on the pursuit of the common good, but on reasons that are outside the competence of the legislature to pursue, or what my colleague Stephanie Barclay, who is here today, has called excluded reasons for enacting a law. Let me offer two excluded reasons. The first is animus towards the right. When legislators are hostile to a right, they may seek to restrict its exercise under the guise of regulating for the common good. Courts should be aware of this animus, be realistic, realistically examine the fit between the means chosen and the purported end. Second, it is not uncommon for regulations to be adopted not to achieve the common good for everyone, but to benefit some special interest groups at the expense of their competitors or of the general public. Both of these ends are excluded because both are inconsistent with a truly common good. But because these reasons are widely regarded as illicit, they are always, or almost always, disguised. Stephanie Barclay has offered three proxy questions a court could ask, or should ask, and do ask, to determine whether legislatures are acting improperly in pursuit of an excluded end or object. First, courts should ask, and now I'm quoting Stephanie, whether the government has other means of accomplishing this goal that don't involve burdening a protected liberty. A court should determine whether the government would be, quote, meaningfully less well off in pursuing its goal through different means, unquote. Second, courts ask whether the government was pursuing its goal in an even-handed way. It should look for regulation that is therefore either over-inclusive, or it should therefore look for regulations that are either over-inclusive or under-inclusive, suggesting a lack of even-handedness or consistency. Third, the legislature should announce its purpose at the time it is enacting a regulation rather than during litigation, and have an evidentiary basis for its judgment that a restriction on liberty will achieve a proper end, evidence that can be produced for evaluation by other people. Now, regardless of who bears the burden of proof, and I have argued for a presumption of liberty, but I'm not insisting on that today, regardless of who bears the burden of proof, putting the burden of production on the government helps assure that a restriction on liberty is a proper regulation rather than an improper subversion of a right. In sum, with rights as regulable liberties, any prohibition of the exercise of such a right should be held unconstitutional, and any prohibition on the exercise of the right should be held unconstitutional, and a regulation of liberty is permissible if there is some satisfactory showing that it is necessary for the common good rather than an improper subversion of the right. Now, in his article, Judd acknowledges the possible role for judicial scrutiny, and that is what he writes, quote, "A natural rights reading of the First Amendment would require the government to act for reasons that promote the public good, and modern doctrine can perhaps be understood or justified as prophylactic rules that help ferret out illicit motives," unquote. To be sure, he then continues, these judicial efforts bear little resemblance to anything that the founders themselves would have endorsed, but they can still be seen as a way of implementing the original concepts of speech and press freedoms using modern doctrinal tools. But in my view, originalists are not bound to adhere to the modes of scrutiny that the founders themselves would have endorsed. Precise modes of judicial scrutiny are not baked into the original meaning of the text. They are matters of constitutional construction or implementation rather than of original meaning. To be faithful to the spirit of the Constitution, implementing rules need to be realistic about legislatures sometimes acting on the basis of excluded reasons and how that threat can evolve over time, requiring different countermeasures. In my view, the Supreme Court needs to get its head right about rights. Judges at all levels need to jettison their conceptions of rights as interests or rights as trumps and adopt the correct view of retained natural rights as regulable liberties. The proper end of government is, in the words of the Declaration, to secure these rights. What rights are these? They are the natural rights whose content is determined as a matter of positive law by the general law of property, contract, and torts. An independent judiciary can contribute to this end by ensuring that these regulable liberties are not unjustly prohibited by a legislature, but that they are regulated in a manner that is aimed at a public good that is truly common to all. Thank you.
Thank you very much, Randy. We will now turn the floor over to Professor Dan Epps, who comes to us once again from Washington University Law School remotely. Professor Epps.
John, thanks very much for that introduction. I'm really sorry not to be there in person after having a really wonderful experience living in Charlottesville for a year and not getting the chance to interact with a lot of the great people at the conference. I am excited to get to talk a bit about my work with Danielle Donfro on general law and the Fourth Amendment. The short version of our thesis is that general law is the best way to understand existing Fourth Amendment doctrine and the most attractive theory of the Fourth Amendment compared to the leading alternatives. Let me put my cards on the table at the outset. I am, at best, a dabbler in general law, and I feel like a bit of an interloper here. Our approach in the paper is not really driven by fundamental and principled methodological and jurisprudential commitments. Instead, it's strategic and instrumental. I am much more of a pluralist than an originalist. But I do think our theory is supported by history and should be attractive to people with more originalist commitments, but that is not our primary motivation. So let me start by explaining the problem we're trying to solve. There's really deep and persistent disagreement on how to interpret the Fourth Amendment. The text is very sparse. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. And it leaves a ton of unanswered questions. Such as what's an unreasonable search and seizure? What's a relationship between the search and seizure clause and the warrant clause? For the last half century or more, the dominant approach has been the CAT's reasonable expectations of privacy test to determine hard questions about the Fourth Amendment's meaning. And under that test, the big question in most cases goes to whether something counts as a search at all. And to answer that question, courts are supposed to ask whether the government activity in question intrudes on a person's actual expectations of privacy that society is prepared to recognize as reasonable. The test was adopted in order to enable the Fourth Amendment to tackle hard questions arising from then emerging technology. Police were using various kinds of wiretaps and other forms of electronic surveillance, and existing doctrine, which emphasized physical trespasses, was not really up to the task of regulating and addressing that conduct. In the Katz case in 1967, the court adopted its new test in order to say that a listening device whereby police could hear a conversation on a phone call in a telephone booth was a search. And the court has applied this test over and over in the decades since. And in doing so, it's generated a lot of criticism. The test has been criticized as indeterminate and is leaving too much discretion in the hands of judges. It's been called circular. As Justice Scalia put it, the way the court has interpreted reasonable expectations of privacy bears an uncanny resemblance to those expectations of privacy that this court considers reasonable. And so there's been a search for a new approach. Justice Scalia pushed one such approach in his later years in the court. he emphasized the idea that the test for a Fourth Amendment search should look to property rights and ideas like trespass. So, for example, in United States versus Jones, a case that addressed the question of whether the police installation of a GPS device on a car was a search, he said that could be resolved by recognizing that installation of the device was a physical intrusion onto the suspect's car. And some scholars have tried to offer more specific versions of this theory. Will Bode, who I think is one of the speakers at this conference, and James Stern, who is a UVA grad, have proposed a positive law model of the Fourth Amendment in which whether something is a search turns on whether the police do something that would be illegal for a private party to do in the relevant jurisdiction. So for a case in Maryland, you look at the specifics of Maryland trespass law. In Virginia, you look to Virginia law. And sometimes you have to drill down to municipal codes and other local laws depending on the specifics of the case. Justice Gorsuch has said he's interested in some form of a positive law, property-based approach, but recognized that there are a lot of hard questions about it. He asks, what source of law determines the scope of protections? Current positive law, the common law at 1791, extended by analogy to modern times, or both? And in some ways, our article is really an answer to his questions. Our answer, though, is neither, and rather it's a third possibility. The source of law to look at is general law. And we think it's better than, for example, the Bode and Stern approach. That one is a very clever theory, but we think it would be immensely impractical. There would be tremendous variation in Fourth Amendment law across jurisdictions. Courts would have to do a lot of tricky work in every case to answer Fourth Amendment questions, and the cases would not really generate useful precedent for future Fourth Amendment cases. And would also lead to some weird and seemingly arbitrary results. And so we offer our different version of a positive law property-based theory, the general law approach to the Fourth Amendment. So under this theory, to determine whether a search is unreasonable, courts should look to the general law. Does the police action in question violate general law principles that would be applicable to a private party? I'm not going to give a lengthy definition of the general law, as the panels have probably already done that better than I can to different extents, although I'm sure that there's disagreement on exactly what it means. But the basic idea as we understand it is that courts are looking sort of for broad legal principles, broad legal consensus, but also to custom, tradition, and social facts that obtain across the country. Now, in many cases, this will involve looking to history. In cases involving traditional trespass into a home, for example. The basic approach today would probably look like it did a couple hundred years ago. But that won't always be true. General law can evolve over the course of history, and it can also address new situations. So there may be evolving general law principles that could help Fourth Amendment law deal with new situations that a 1791-based approach wouldn't be able to handle. Privacy torts didn't exist in 1791. They emerged in the early 20th century. But they may now be understood as incorporated into the general law. We don't take a firm position on that question, but it's at least a possibility. And if so, they might help courts find hooks for the Fourth Amendment to regulate new forms of intrusion that violate some of the values that we think the Fourth Amendment is meant to protect. So what is good about this approach? Lots of things, and we think in particular it's good in lots of ways that make it superior to the leading alternative theories, even if it is not itself a perfect theory. So what are the advantages? Okay, first, we think it's more consistent with the text of the Fourth Amendment than a lot of the leading approaches. So, for example, both the Katz test and the Bode and Stern test put all of their emphasis on how to define the word search in the Fourth Amendment. That's where all the action is. And the Katz test determined whether something is a search. That's where this idea of reasonableness comes in. We think that's a very strange way to interpret the Fourth Amendment textually. And so we think more of the action should be on the word unreasonable, which is in the text. And that many things may qualify as searches, which are basically just, ways to obtain information, but not all of them are unreasonable. We think relying on work done by others like Laura Donahue, Thomas Davies, that the word unreasonable is best understood as some kind of reference to the common law. But we think not as a reference to a fixed body of 1791 common law, but to more general principles of common law. And at the time the Fourth Amendment was enacted, common law would have been understood at least as capable of change and evolution. So that's text. We think it's a better way to, and more consistent way to interpret the Fourth Amendment in light of history. So today, the Fourth Amendment is enforced and interpreted almost exclusively in criminal cases through the remedy of the exclusionary rule. There's some civil cases under Section 1983 enforcing the Fourth Amendment, but they are a much smaller slice of Fourth Amendment law. That's not the way it worked originally. The traditional way to enforce search and seizure protections was actually through tort suits for trespass against the individual agents of the government who had intruded and committed an unreasonable search and seizure. And what the Fourth Amendment was doing was kind of preventing warrants, improper warrants, because warrants would have provided immunity to the official who conducted the search and seizure, immunity in such a tort suit. And our claim is that in such suits, courts would be more inclined to kind of think of their project as something looking like general law, not the modern kind of strict positivist conception of law as merely the command of the relevant sovereign that we think underlies the Bode and Stern approach. We think it's much easier to reconcile with what the court has been doing in terms of precedent. So if you look at the kind of more recent property-based approaches pushed by Justice Scalia, we think this is much more consistent. So for example, in Jones, the GPS case I mentioned a few minutes ago, the court didn't make a nuanced look into the specifics of District of Columbia and Maryland trespass law. That's where the relevant government conduct occurred. Instead, it seemed to ask more general questions about, what are the principles of trespass? Likewise, in a case called Jardines, which involved the question of whether police bringing a drug-sniffing dog up to the front door of someone's house constituted a search, the court there, in an opinion by Justice Scalia, did not look to the specifics of Florida property law. Instead, it looked to general principles of license and curtilage and to the habits of the country. And again, we think that looks a lot more like a general law type approach. We think that in the pre-Katz cases, we think the court actually did something similar, looking to sort of broader general principles of ideas like trespass. We do think our approach can actually be reconciled with much of the outcomes of existing Katz cases, even if not precisely the reasoning. So it would lead to different results in some cases, but it does not require overruling the entire history of Fourth Amendment jurisprudence over the last 50 plus years. We think this approach gives the court more flexibility to deal with new situations than, say, the Bode and Stern approach, and more flexibility than a approach that treats the Fourth Amendment's protections as frozen in 1791 amber, because they can recognize new general law principles as they might evolve. But at the same time, we think this approach still provides more constraint than the dominant Katz approach that involves judges just kind of speculating about what society might find reasonable. We also think this approach better accords with underlying Fourth Amendment values. The Katz test really makes privacy the touchstone of Fourth Amendment protections. We think if you look at the Fourth Amendment's text, for example, and if you look at the background of the Fourth Amendment and the kinds of things that the framers and ratifiers of the Fourth Amendment would have been most concerned about, it wasn't just about privacy. It wasn't just about disclosure of private information, but it was about security in one's person and property. And this approach enables Fourth Amendment courts to provide more protection for those values. I'm not going to go into a lot of detailed examples in the interest of time, but just to quickly talk about a few examples of how it might change things. So one, abandonment. Courts have addressed the question of whether someone is living at a home. If they then leave, have they abandoned their home such that the police can search it freely? They have just addressed that question through principles of expectations of privacy. We actually think there's a very rich body of property law that would enable them to address those kinds of questions in a more determinate way and in a way that actually provide a bit more protection. With a lot of cases involving personal property, involving vehicles, again, courts have just looked at kind of vague privacy conceptions. We think the law of bailment might actually provide a more determinate and useful source of protections. And in a more adventurous way, we do think there are some creative ways that general law type principles might help courts deal with the most cutting edge situations. So one situation that has emerged recently that courts are really struggling with is it a search, does it violate the Fourth Amendment for police to put up a camera on a telephone pole and aim it at your house and record everything that happens at your front door for a week or a month or longer? The CATS approach so far has led to the conclusion that that's not a search. A lot of people find that troubling. We point to some emerging principles and cases in kind of property law where that kind of conduct conducted by homeowners against their neighbors actually has been found to constitute a violation of common law type principles. And we think that could be a fruitful source for protection, maybe not today, but as the law evolves there. So for all those reasons, we think this is a vastly superior approach and one that deserves a lot of consideration by courts, and particularly by justices like Justice Gorsuch, who are really out there looking for a new approach, but haven't quite settled on the right way to do it.
Thank you very much, Professor Epps. We'll now turn to to Professor Robert Leider, who comes to us from our fellow Virginia Law School just up the road at George Mason.
All right. Thank you very much for inviting me to join the panel discussion here today. I apologize that I am not able to join in person, both because I was teaching this morning and because since I've accepted this invitation, I have acquired a second job as chief counsel of the Bureau of Alcohol, Tobacco, Firearms, and Explosives. And with that, I have to start with the obligatory disclosure that what I'm about to say reflects my personal views as an academic. They are not the views of the U.S. government or the agency for which I work. They may, however, be applied versions of the views of two of my co-panelists, Randy and Steve, for whom I owe a large debt of intellectual gratitude. I think I've had, two the introduction of general law and the Second Amendment to me has, I think, occurred in two big waves. One was when I was writing an early article on how the Second Amendment and state analogs have been interpreted over time. I noted in a footnote in my introduction that the Second Amendment and various state analogs were basically codifying the same pre-existing right. I think the fact that it was banished to a footnote was a reflection that I largely didn't understand the deeper concepts of general law that I was muddling around in, and which I learned quite a bit from the work of Steve, Judd Campbell, and Will Bode. And the other was reading state cases on the right to bear arms, which heavily involved how the right to bear arms could be regulated. And the state, for 160 years before Heller was decided, state courts treated the right to bear arms as an individual right. And yet they did not treat the constitutionalization of the right as an absolute trump to regulation. State court decisions were near unanimous that the right could be regulated using the state's police power. And as today's lecture from Randy has shown, Randy has, I think, reinvigorated this idea of regulable rights, and my work has benefited enormously from the lectures that he has given, as well as some discussions from my colleagues Eric Claes and Adam Ossoff, who have studied the police power particularly in the context of regulating property rights. And so while they're getting me a little bit from the shadows of Plato's cave, I don't think I'm anywhere near seeing the forms at the moment, but I think understanding general law has been hugely helpful to understanding how the Second Amendment is supposed to function both as a right and in terms of what regulations on the right are permissible. And so fast forwarding to Bruin has sort of the Supreme Court in Bruin has laid out the standard of how Second Amendment laws are supposed to be evaluated. And the court said, and I quote here, "When the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. The government must then justify its regulation by demonstrating that it is consistent with the nation's historical tradition of firearm regulation. Only then may a court conclude that the individual's conduct falls outside the Second Amendment's unqualified command." And I think if we look to legal principles here, the validity of modern firearm regulations really turns on two questions. The first is whether the conduct that's alleged falls within the protected right. And if it's not, then the government is free to regulate subject to other constitutional limitations. If it does fall within the right, then I think the second question, the one that Randy discussed in some depth, emerges, and that is whether the government's exercise of the police power is a reasonable regulation of the right. And here I want to contend that both of these questions are general law questions. So first, let me start with the scope of the right. The operative provision of the Second Amendment says the right of the people to keep and bear arms shall not be infringed. And I think when the Second Amendment referred to the right, it meant the pre-existing right at general law. And until recently, I don't think this principle was controversial. If you look at United States versus Cruikshank, which was the first Supreme Court decision to really engage with the Second Amendment other than in dicta, the court there said, quote, "The right there specified in the Second Amendment is that of bearing arms for a lawful purpose." The right there specified in the indictment that they were alleging is that of bearing arms for a lawful purpose. This is not a right granted by the Constitution, neither is it in any manner dependent upon that instrument for its existence. The Second Amendment declares that it shall not be infringed. And so I think here what the court was saying was that the Second Amendment was a pre-existing right. I mean, this is why under Slaughterhouse, they could not enforce the right using Slaughterhouse's interpretation of the Privileges or Immunities Clause. But the right was not one that was generated by or created by the Constitution. It was not a new right. And that went on all the way up to Heller. If you look at the government's brief in United States versus Miller, which is the first major Supreme Court case directly on the Second Amendment, that occurred about a year after Erie. And the government's brief says here, and I quote again, "The Second Amendment does not confer upon the people the right to keep and bear arms. It is one of the provisions of the Constitution which, recognizing the prior existence of a certain right, declares that it shall not be infringed by Congress." And the brief continues. Accordingly, in determining the nature and the extent of the right referred to in the Second Amendment, we must look to the common law on the subject as it existed at the time of the adoption of the amendment. And then the government went on to assert arguments that were grounded in general law based upon federal and state constitutions having approximately the same meaning. And when the Supreme Court decided Miller, it decided it on general law principles. It gave a rule of which arms were protected, that rule came from an 1840 Tennessee decision under the Tennessee state constitution. And why was that valid? I think that was valid because the government was assuming that the state constitutional right to bear arms was of approximately the same scope as the federal one, that they were codifying the same pre-existing right. And the court went on at the end of the opinion to note that the different jurisdictions had reached somewhat different opinions concerning the scope of the right guaranteed, and then it cited them. But it said none of those decisions seemed to offer any support for the challenge ruling below. And I think, Miller there is making an assumption that the Second Amendment is codifying what was the general law principle. It was looking to the general law to decide the case, and it noted that in this case, opinions about the general law overlapped, and it had no problem holding that the particular weapon there was not a protected arm. And it left the disputes about the general law for another day. And I think from this end, Heller sort of marked a break from prior Supreme Court practice. In Heller, Justice Scalia took a textual analysis of what the Second Amendment protected, looking towards the public meaning of keep and bear, and I think a little less historically, although it came in a little bit at the end when he started talking about the limitations of the right. And so, as I argued with Will Bode in an article, I think Bruin may mark a return to the general law model. Bruin is much quicker on the text. It said, of course, the right to bear arms includes the right to carry it. Where the lengthy exposition came was in demarcating the historical regulations of the right. And so I think what the court is trying to say in Bruin is to say that when you look at how to regulate the right, you look to the general law. You look to the historical tradition of regulating firearm ownership. Now, when we look to the general law, what does that mean here? And I think, as I'm sure the prior panels have stated in some depth, it is the law that spans across jurisdictions that is perhaps the default law if no other law displaces it. But I think it's important, especially in the Second Amendment context, to emphasize that the general law is not perfectly uniform across variation. I think the general law gets implemented in ways that are sensitive to the local legal system. So, for example, when you look at the English Bill of Rights, the right to bear arms there is the right of Protestants, and it is suitable to their condition and such as are allowed by law. The American version, you will note, lacks many of those limitations. We don't have nobility in the same way that England did, and so even though we recognize a general right to bear arms, it is not implemented in exactly the same way as England's general right. It is translated over to American common law. The same way, too, between the federal and state governments. If you notice the state constitutional provisions on the right to bear arms, they are not perfectly coextensive with the federal constitutional guarantee. So you will have had states in the antebellum South, for example, secure the right only for those who were members of the political community. And that changed as the United States had greater inclusivity about who made up the political community. You also had some disagreements about exactly why the amendment was protected. Some states, like Massachusetts, said that the right protected the right for the common defense. Others said explicitly it was a right of both individual self-defense and common defense. So just because it's a general right does not mean that how England interprets the right or how the federal system interprets the right is uniform and controlling across jurisdictions. And on this, it might be a little bit different from certain versions of, say, merchant law, where you might have different opinions about what merchant law is, but you might want merchant law or admiralty law to be more uniform across jurisdictions. But here, I think the basic right is uniform. The implementation is not. Now, I think determining the original content of the right to bear arms has been challenging and problematic. And as Will said in his opening remarks, the common law is built on both custom and reason. Custom usually comes first. Lawyers are trained to look first to authority, and then eventually authority will displace first principles reasoning. But the problem in the Second Amendment context is that there's very little authority from which to draw. There just weren't that many, there weren't any court cases about the Second Amendment. And I think the fact that there's not a ton of authority has led to great disputes. But there are other areas we can look to. We can look to the common law. And the government's brief in Miller that I just quoted was citing a proposition from State versus Workman that the keeping and bearing of arms, which at the date of this is a quote from the case, which at the date of the amendment was intended to be protected as a popular right, was not such as the common law condemned, but was such a keeping and bearing as the public liberty and its preservation commended as lawful and worthy of protection. And so when I think in accordance with this principle, this is why you see in a lot of Second Amendment cases dueling briefs about what the common law protected, because in absence of judicial decisions giving us controlling authority, we look to other forms of authority, and the general right, we presume, is the general right that was consistent with the common law as the common law existed at the time of ratification, which I think is another important limitation because the right has evolved over the centuries. And I think it's a mistake to say, let's look to the 14th century common law as giving controlling authority to what the framers would have codified in 1791. But even here, the common law, there's not a ton of authority on the common law. And without judicial decisions interpreting it and without a lot of detailed treatises, the full scope of the common law is probably unknown and unknowable. And so I think Second Amendment litigation, as it exists today after Bruin, has been this search for custom without a corresponding search for reason. And I think there are kind of two reasons that are motivating that. The first is there's, at a very fundamental level, basic disagreement about what ends the Second Amendment achieves. And I think there are two competing philosophies for what the Second Amendment's trying to do. The first is kind of a military public defense idea, that what the Second Amendment does is allows individuals to act for the common defense, because if you don't have citizens who can do military service and do law enforcement, you have to rely on professionals. And for the framing generation, having a standing army of regular soldiers enabled the government to exercise power potentially beyond what the community would accept. And the second version is that the Second Amendment, the right is useful for individual self-defense against crime. And what you've seen out of the Supreme Court is an emphasis of the individual self-defense against crime rationale and largely silence about the public defense rationale. And without, as I'll come back to, without having some teleology about what the right protects, I think it's hard to determine what a reasonable regulation of the right is. And I will come back to that at the end. I think the second reason that we've been heavy on custom and light on reason is that the Supreme Court perceives that lower courts are not faithfully applying the Second Amendment. And as a result, to narrow lower court discretion, I think they seem to believe that custom provides the best way to do that. Although I would say I think recent decisions challenge that belief. As we're seeing out of the courts of appeals, you can pretty much analogize to anything. And I'm not sure the search exclusively for custom is solving the underlying problem. So I think at the end of the day, this area is not going to settle until we engage with the first principles, which will generate authority and then will in turn help settle the area of law. Now, the second question I was going to raise here was how far the government could go in regulating the right. And I think here Randy's presentation took a lot of wind out of my sails. A lot of what I was going to say is pretty much coextensive with what he said. I will briefly summarize it. I had a slightly different way of presenting it, but I think it's going basically in the same place. But I think the answer to the question that conduct's protected by the Second Amendment doesn't answer, it's not at that point an absolute trump. You still have the regulation question. And again, courts are answering the regulation question just by looking to custom, just by trying to analogize from historical regulation. And I think this is a serious mistake. I think to figure out how to regulate a right, you have to look to the general law of the police power. And, traditionally, the police power allows the government to do certain categories of regulation. And I'm going to present it slightly differently than Randy did, but I think it's pretty much what he said in slightly different words. I think there are four things at least that you're looking at to determine whether the government is properly, or the four interests, I should say, that the government has in regulating the right. The first is the government can regulate rights to make rights regular. So as Randy says, if you want to do something, here's how you must do it. So the power, as Randy notes in one of his articles, the power to regulate elections isn't the power to forbid them. It says, here's the date and time, here's how you cast a vote. I think some of the reservations in Heller are of the same character. That when Heller says it's not an infringement to have laws prescribing commercial qualifications for the sale of arms, what it's talking about there is a law which says go to a gun store, give your name and address, isn't really infringing the right in any sense. It's just telling you how to exercise the right. The second is to prevent conflicts of rights. So sometimes, especially in the Second Amendment context, a person's rights will go up against somebody else's. So suppose a person wants to carry a gun for self-defense, but another person wants to ban guns on his private property. The law will often mediate that. So you've seen the rise of statutes in a lot of states that say, well, you can bring the gun on the property in violation of the private property holder's wishes, but you have to leave it in the car. And there what you're seeing is the government trying to sort out and saying, no, you can't broadly infringe the person's private property right, but we also don't want the person's private property right to have huge spillover effects such that if you're visiting that property, you have to leave your gun home for the day. So the second is preventing conflicts of rights. The third, and perhaps the most important in the Second Amendment context, is preventing people from exercising their rights in a way that infringes the rights of others. And so a lot of regulation on arms is regulation on either unlawful uses or on uses that may lead to unlawful usage. And I think the fourth is to secure an average reciprocity of advantage. So a valid police regulation may be preventing armed groups from intimidating others into not exercising their rights. And then from there, once you have a valid reason, from there you have to look at the magnitude of the burden. And Randy covered this, so I'm just going to go very quickly. But I think, I think the two things on the valid reason, one, do you have it? And the second, which Randy noted, and I think he's absolutely right, is there evidence suggesting that the problem is a real problem, is a problem in real life, not just a specious problem or a hypothetical problem? From there, I think you have two questions on the burden of the right. First, is there a reasonable fit between the asserted interest and the right being enacted? And if there's not that fit, there's often an inference that the regulation is pretextual. And the second thing is, if there is that fit, is there a proportionality between the purpose and the burden? Are you imposing a gratuitous burden? Are you snuffing out the core of the right, which would have been a prohibition rather than a regulation? And I think I've talked for a while. Let me give a couple quick examples and I'll wind it up there. I think after Bruin, we see examples of a lack of reasonable fit between the asserted interest and the regulation. So one of these is challenging so-called default rules on carrying weapons on private property. A lot of states have responded to Bruin by saying, well, you can't bring a gun on any private property, business, home, anything, unless you're invited. And I think what they're trying to leverage here is that nearly all property owners don't post whether guns are allowed or prohibited. But they also say that rule only applies to citizens carrying guns on permits. Police officers, off-duty police, retired police, sometimes state court judges, administrative law judges, whole categories of people can carry guns on private property unless it is otherwise posted. And so what I think you see here is no fit between the asserted interest, protecting private property rights, and the method that has been chosen to accomplish those ends. What you're seeing, I think, instead is pretextual legislation designed to leverage private property to prohibit the right for one group of people. Overburdensome regulation, I think New York City's Times Square regulation, where they covered not just Times Square, but half of Western Manhattan around Times Square, what is called the Times Square Business District, but is far larger than the crowds that you see at Times Square. Too much of a burden. I think Bruin was the classic example of too much of a burden. After Bruin, New Jersey's law prohibiting all loaded firearm carrying vehicles. I think jurisdictions with buffer areas are also in this too much of a burden category. Sometimes you see laws that say no guns within 100 yards of any place of public assembly, including a park, school, library, recreation facility, or hospital. Now, maybe you can have one buffer zone, like the White House might not include just the White House, but also the adjacent sidewalks and streets, but you can add up the buffer zones in a way that you can't meaningfully exercise the rights. But I think my last point is to understand the sort of proportionality and whether you're frustrating the core of the right, you have to have a theory of what the right does. And I think the case where you will have vastly different perspectives are laws prohibiting certain semi-automatic firearms that often go under the label of assault weapons. And I think here, if all the Second Amendment protects is a right of individual self-defense, which many courts have held under both federal and state constitutions for the last 30 years, then those courts have not had much trouble upholding their assault weapons bans because they say, look, the bans leave a vast array of other weapons available, so the core interest of individual self-defense isn't being infringed, and we're addressing a public safety problem with mass shootings. On the other hand, if you see the Second Amendment as not just guaranteeing a right of individual self-defense, but also a right of public defense so that individuals can perform military and law enforcement services, a prohibition on rifles that have military utility cuts to the very core of the right in the same way that a ban on political speech is not a narrow ban on one type of speech for purposes of the First Amendment. And so far, we've been muddling along trying to figure out reasonable regulation without having a deeper understanding of the teleology of the right to bear arms. But I think for a lot of these cases going forward, like the assault weapons case, you can't answer the question without having a deeper understanding of what the Second Amendment was trying to accomplish. So I will end there and let Steve have his presentation. Thank you.
Thank you, Professor Leider. We'll now go to Professor Sachs, coming to us from Harvard Law School. I know we are running slightly behind schedule, so I've gotten permission to perhaps have a few extra minutes, just so Professor Sachs does not feel like he has to be exceptionally hurried in his remarks.
Thank you so much. I very much appreciate it. I'm not sure that I will take all of the extra minutes to avoid harryment, but I appreciate the offer nonetheless. I will be talking today about what restoring the general law might mean for the question of interstate relations. So when people hear about the idea of the general law, their first thought is, oh, the bad old days of Swift v. Tyson, when federal courts purported to make law for the various states in all sorts of ordinary contract and tort and things like that. I'm not sure that that in fact was what the regime of Swift v. Tyson looked like. I don't think federal courts were purporting to make law so much as attempting to find it. But even if one takes those critiques seriously, I think there's a very large area of law where the general law would make a real difference, which is the law of interstate relations. Questions that cannot be governed by the law of any one state, but also are not obviously governed by any actual federal law. So in Swift v. Tyson, it made a distinction between the state's choice to use a more general tradition to incorporate the common law as part of the law of New York, let's say, and its decision to have its own statutes or its own local usages on a topic. So a state might very well say, look, in general, we follow the common law of contract, but we have a few rules here that are different from the general law of contract, and so we actually do our own thing. And on the Swift v. Tyson model, you would say, fine, that's your law, that's part of the laws of the several states under the Rules of Decision Act, and you get to do that. Under the world of today, when we have a very different sort of picture, and 80 years post-Erie of doing something that is not very general law-like, I would say that most of state common law takes the form of local usages. California is no longer trying to follow some sort of general law of tort. They have their own law of tort, and that's just the local usage. And so even a court that was ready to pick up the Swift v. Tyson pen would in fact need to follow what the California courts think California law is on a wide range of topics where it is clearly governed now by local usage rather than by general law. But there are a number of interstate topics that do not seem to follow this model. So as many people will remember, on the same day as Erie, we had the Leider decision. It was a question of water apportionment between various states. And the court held, and here I'm reading, whether the water of an interstate stream must be apportioned between the two states is a question, ... upon which neither the statutes nor the decisions of either state can be conclusive. And that seems to make a lot of sense, that, we're not going to listen to whether, Kentucky or Tennessee gets the water. One state can't just declare we get all the water. And so we would have to have some other kind of law to settle the question. The problem is what the court used to fill in the ... because it had just said earlier that day in Erie that there is no federal general common law. And so instead what it stated that it was a question of, quote, federal common law, upon which neither the states nor the statutes nor the decisions of either state can be conclusive. So it invented a new category to try and solve the problems it had created earlier that morning in Erie. Now, what does it mean to be federal common law? Well, over time, we've determined really three features. First, it is preemptive. So if you have federal common law, it overrides state law to the contrary. It's treated as federal law for purposes of the Supremacy Clause. Second, it is treated as federal law for purposes of Article III subject matter jurisdiction, even though it is not a law of the United States as described by Article I, Section 7. Federal common law is treated as arising under the laws of the United States for purposes of Article III. And moreover, because it is common law and not statutory, Congress is believed to have a power to change it. This is very different from what the prior model would have been of general law, where it is not preemptive, it doesn't override state law, but it might exist outside it. So if it's the case that we won't look to the laws of New Jersey or of New York to determine some water apportionment problem, this is not one of the cases where they apply, as the Rules of Decision Act would have it. The theory of general law is not that it stands above the state law, but rather it just stands outside the state law, and if we don't look to state law, we might look to that instead. Indeed, it might stand below the state law. It might be, as Marshall said, the substratum on which state law is built, and so it might be that in the absence of any state law we can look to, we sort of fall through the cracks to the general law below. Moreover, general law doesn't offer you Article III subject matter jurisdiction. It's not part of the laws of the United States. But we might have a number of actual heads of Article III subject matter jurisdiction that would enable you to take a case involving these issues to federal court. So on the issue of water apportionment, we have state-to-state jurisdiction that goes original jurisdiction straight to the Supreme Court. And all of these are, cases would very easily go there. Or if there's a question between private parties, you have the diversity jurisdiction to allow lower courts to adjudicate these general law matters in the first instance. And while general law doesn't necessarily entitle Congress to change the law, it's a question of enumerated powers of what things Congress can and can't change, that seems perfectly appropriate here. For it's not at all clear that Congress could just declare how much water in a given river belongs to one state or the other. Maybe that's a question of commerce among the several states, but not necessarily. If you're taking a straw and drinking water out of your side of the river, it's not clear that you're doing anything interstate when that river is within your borders. And so it's not obvious that the Commerce Clause would allow Congress to say all the water goes to Kentucky or all the water goes to Tennessee. It might be an issue that Congress is powerless to change, but that the federal courts in the exercise of their ordinary jurisdiction would be able to apply any traditional principles, including any adjustments that the states reach by interstate compact. So what are some other areas where this model of general law supplying the law of interstate relations might be helpful? One, I think, and sort of the classic example for this is state borders. So in state border cases, there are lots of old weird rules that courts use. So for instance, if a river that's the border between states moves slowly by accretion, we say that the border follows the river. We don't say that if the river moves a very slight 3 inches, that there's now 3 inches of New Jersey on the other side. Instead, we just say the river is still the border. But if it moves evulsively and quickly and visibly, as in the case of a sudden flood or something like that, we don't say that you lose half your territory because the river moved. We say that that evulsive change leaves the borders intact. There are even more detailed rules. So for instance, normally if the river is the border, we use the middle of the river for a non-navigable stream. Or if it's a navigable stream, we use the thalweg, which is the middle of the main navigable channel, to make sure that both states can access it. That rule is, not coming from any textual source. That's just an old rule of international and general law, but it is used by the Supreme Court all the time in state border disputes. Now, what kind of law is that? Well, it can't be state law. It cannot be that New York can just announce by its own law that we now own part of New Jersey, say Ellis Island, as came before the court a while back. It also can't be federal statutory law because there's no statute on the topic. No statute enacts the Thalweg rule. And moreover, we don't think Congress even could award part of New Jersey to New York, even if they wanted to. Article 4 bans Congress from creating new states by joining states with the parts of other states unless you get the consent of everybody's legislature. And New Jersey is not okay with having Ellis Island handed off to New York. So it seems like the Constitution would forbid Congress from enacting statute law here. It also seems that on any sensible theory of constitutional interpretation, this cannot be constitutional law. The Constitution says nothing about thalwegs. We might infer lots of structural principles from the Constitution, but there are lots of different ways they can go. They wouldn't necessarily endorse the middle of the main navigable channel. There are lots of ways that you might be consistent with constitutional structure. And if all of our structural reasoning is just somehow exactly copying the content of the old general and international law rules of state borders, we might suspect that something else is going on here. Finally, it couldn't be federal common law. It can't be that it's just a matter of federal common law as to where the state's borders are, in particular because, again, Congress is not able to rewrite it. So if it were federal common law, it would be federal common law of a unique and very different kind. That is why it seems to make a lot more sense to think of areas like this as general law. We get it from all the old sources with all of their wrinkles. They do not need to be preemptive because they're outside state law. So long as a federal court would not look to New York law to see whether it owns part of New Jersey, it doesn't matter whether the general law rules about thalwegs preempt a New York law to the contrary. New York just lacks the authority to arrogate to itself any property that the general law would not already give it. It, moreover, doesn't need to create Article 3 subject matter jurisdiction because, again, we've got plenty of heads of jurisdiction that were created specifically for this purpose. The idea of state-to-state jurisdiction was created in large part to avoid border disputes that were already going on and that we knew needed to be resolved somewhere, and so they put them in the Supreme Court. Or diversity suits. If you've got citizens of different states arguing about where their land comes from, what state it's in, you can have that go to a federal court. Likewise, if you have citizens of the same state claiming land under grants from different states, which of course depends on a contest about what state that land is in, that is an explicit head of federal jurisdiction. They were planning for disputes of this kind to go to a federal court. We do not need or even want Congress to be able to override these general rules because we want an independent arbiter in the federal courts to be able to decide according to whatever the traditional rules were. So these are sort of relatively unsurprising applications of general law in a world where we are revising Erie, willing to look past it, willing to look behind Leider's creation of a category of federal common law. And one question is, are there any others that might have greater significance? And I think that indeed there are. So one area I've argued about is personal jurisdiction, a question not about where the state borders are, but what state borders mean. To what extent can a state reach beyond its borders to adjudicate cases? Before Pennoyer, there was no 14th Amendment due process clause, but there were plenty of personal jurisdiction cases. Whenever a case was heard in one state, and then the judgment was sought to be enforced in another state or in a federal court, you would have to consider under international principles, general law principles, whether that first state, even if its own law permitted it, actually had jurisdiction of the parties and the cause. 14th Amendment's passage, as Pennoyer noted, gave teeth to these existing standards, but it didn't supply new ones. It's not as if the Due Process Clause hid a lot of rules about personal jurisdiction as if in invisible ink. Instead, it merely said that if you take someone's property away without due process of law, which Pennoyer very sensibly understood to require, among other things, a judgment of a court of competent jurisdiction, then that was a deprivation without due process. So if there was no jurisdiction under the standard traditional rules of jurisdiction, under whatever rules you had to look to, and in the absence of federal statute, a federal court could only look to general law on that topic, then you would say that there was also a constitutional problem, a deprivation of property without due process. After Pennoyer, this understanding was sort of condensed so that people started saying 14th Amendment due process requires X and Y and Z as a matter of personal jurisdiction. And of course, that's very strange because 14th Amendment due process doesn't say anything about it, which is one of the reasons that the Court in International Shoe was able to throw aside so much of the old doctrine on the theory that, look, this is 14th Amendment due process, so it's really got to be about fundamental fairness and traditional notions of fair play and substantial justice, etc. So why does this distinction matter? Well, it's not just a good historical explanation from how we got from there to here. It also helps us understand why all of these old rules about consent and tag jurisdiction and service of process and things that don't seem very consistent with our ordinary understandings of due process could nonetheless be actionable under the 14th Amendment's Due Process Clause. So when we have cases about the scope of consent, as in the recent Mallory decision, cases about whether the Fifth Amendment imposes similar restrictions to the 14th Amendment, as in the pending Fold case, all of these things might be more sensibly answered if we understand the substantive rules of jurisdiction as coming from general law and not as being fixed in constitutional amber. For one thing, it might be the case that the rules of general and international law might change over time, or it might be the case that the rules of general and international law are whatever they were the last time that we were using them. So in the same way that one might say, at common law, burglary had to be at night, because the last time we were doing general law of crimes, that was the rule, and the departures from it were statutory rather than unwritten. It might be that the sort of state of federal jurisdictional law circa the 1920s or so is the correct understanding of the general law as it is now, because that's the last time we were really doing the general law of personal jurisdiction. So we would need to ask, what is the actual general law now? And moreover, how has it been lawfully changed? So if Congress has power under Article 4, under the effects clause of the Full Faith and Credit Clause, to prescribe the effect of a judgment of one state in another state, and early proposals to use that power were very clear about its applying to questions of personal jurisdiction. If that's the case, maybe Congress is able to redraw the rules of personal jurisdiction in a way that it can't redraw the rules about state borders. A second major area where this sort of revival of general law of interstate relations might matter is choice of law. Again, a question of what state borders mean, this time for legislatures rather than judges. So when a state legislature says murder is illegal, we usually don't assume that that includes murder on the street of Berlin, because that's not where that statute would ordinarily be applied. We have a notion of where the statutes of the various states can and are applied. And those notions used to be drawn from general law. And to the extent that there was a controversy over them, often they could go to federal court, not because they were federal common law of any kind, but rather because the existing heads of jurisdiction allowed for it. So if you've got citizens of different states, as typically would be involved in such circumstances, you could go to an independent court and get an independent forum that would not be bound by any choice of law rules adopted by one state or another. In the 20th century, with the abandonment of general law, this was constitutionalized, but very unevenly. So sometimes the Supreme Court has said that the full faith and credit clause requires or forbids the application of a particular state laws, but most of the time under the all-state test, it's pretty much anything goes. Any argument that a state has, that it has a state interest here because of some contact, making the application of its law not arbitrary or unfair, will basically be fine under the full faith and credit clause and the due process clause as the courts currently interpret them. And because of the Claxon decision, making federal courts follow the choice of law rules in the state in which they sit, there is no escape to an independent, neutral federal forum. So that means that sometimes, even under federal statutes, it will be necessary to apply the choice of law rules of a state. So take, for example, the Copyright Act, which provides various rights to the children of the copyright holder. Well, who's a child? Normally, that's a question of state law. And if you adopted a child in state A, but in a way that was illegal under the law of state B, which is where you lived at the time, is that person really your child? This is an issue of choice of law, which, at least as the Claxon decision would have it, would force a federal court deciding a copyright case over which it has exclusive jurisdiction to decide that case according to the laws of the state, of the choice of law rules of the state in which it sits, when in fact the choice of forum might be entirely determined by the plaintiff and might have nothing to do with the underlying merits of the suit. At the same time, the court has cut back rather drastically on states' ability to follow their own choice of law rules whenever the topic is described as one of due process or dormant commerce. So for instance, in BMW versus Gore or in the State Farm case, the court has declared that a state cannot punish conduct that was lawfully done in another state. That seems like a choice of law question, but nonetheless, the court has said that the 14th Amendment imposes a strict rule of territoriality there that it does not impose in cases of compensatory damages. And with regard to things like the internal affairs doctrine for corporations, the courts have created very complicated dormant commerce rules, which again are much more exacting than the same rules as they would have been understood as a matter of full faith and credit. Now, there are some arguments that choice of law might, in fact, be an area that is constitutionalized under the 14th Amendment in the same way that Pennoyer was, that it sort of gave federal teeth to the existing general rules. And this would depend on some of the arguments other panelists have raised about rights and the police power. The early cases that found constitutional rules about choice of law were not full faith and credit cases. They were freedom of contract cases. They were sort of Lochner-era cases like Allgaier, which said that Louisiana could not stop you from entering a contract in New York and therefore could not, it lacked the police power to sort of reach out and regulate things done elsewhere. And one question is, sort of, what is the constitutional hook for that? Is that a privileges or immunities rule? If Slaughterhouse was wrongly decided, is that a due process clause rule? Would it apply to corporations that lack privileges and immunities, and so on? Moreover, we might need to ask, does Congress have authority to override these things? So Congress has power under Article 4, again, under the Effects Clause, to prescribe the effect of the acts of different states in other states. It hasn't really used that power except in a few narrow areas involving child custody and marriage. And if the underlying rule of choice of law is that it's actually state law under Claxon, it would be very hard to explain Congress's power here. But if this is a form of general law that might be given constitutional teeth depending on what the law provides, then it might be more comprehensible that Congress might have the ability to prescribe the effect of one state's law in another, and a violation of that might violate both the federal choice of law statute and also 14th Amendment due process or privileges and immunities, depending. Finally, there are a few other areas that I want to merely gesture at that might be affected by this new understanding of general law. One is sovereign immunity. So a few years ago, in the case CFTB versus Hyatt, the court announced a new principle that states were immune from the jurisdiction of other states through sovereign immunity, and they declared that this was a constitutional principle, but it's very hard to find in the Constitution. On the other hand, it's very easy to find as a matter of general law and the sort of nature of sovereign immunity that predated the Constitution. Nothing in the Constitution gives one state's court the power to call another state before it. And so you can imagine states seeking injunctions from the U.S. Supreme Court to prevent suits by other states, or just disregarding their judgments and contesting it at the enforcement stage the way we used to enforce all rules of personal jurisdiction. Another area would be the burgeoning area of the federal common law or state common law of nuisance. So a number of suits have been brought against out-of-state corporations claiming that climate change is a nuisance and that their use of climate change, warming gases like CO2 is a nuisance in the forum state. And there's been an attempt to argue that that violates various rules of federal common law, which probably does not exist. On the other hand, the rules discussed above of personal jurisdiction and of choice of law might, if actualized, provide more determinate answers to cases like these. They might prevent states from reaching out and regulating the carbon-emitting behaviors of corporations outside their borders. And it might be that we get a more coherent theoretical account of what's really going on in these cases than from the made-to-order kinds of federal nuisance law arguments that are being brought up today. So I'll stop there. Thanks very much for your time, and I look forward to questions.
Thank you very much, Professor Sachs. And I think that the length and breadth of the presentation shows just how interesting this topic is, but it has also exhausted our time. Though I personally was incredibly thankful for hearing the rule of the Thalweg, which was a major issue in one of the cases that was decided the year I was clerking and was a favorite of the then Chief Justice Rehnquist. I think it's amazing. One of the great things about the general law is you get to use old doctrines like that. They become vital once again. So I am incredibly excited by that development. But we will thank our speakers. Let's give a hearty round of applause for them.
Yep, so that concludes our 6th Annual Originalism Symposium. Thank you again to all of our panelists and speakers, and to you all for attending. Thank you.
Thank you.